Obergeffel vs. Hodges, Gr. Number 14556, June 26, 2015. United States Supreme Court. Facts: Michigan, Kentucky, Ohio, and Tennessee define marriage as a union between one man and one woman. The petitioners, 14 same-sex couples and 2 men whose same-sex partners are deceased, filed suits in federal district courts in their home states, claiming that respondent state officials violate the 14th Amendment by denying them the right to marry or to have marriages lawfully performed in another state given full recognition. Each district court ruled in petitioners' favor, but the Sixth Circuit consolidated the cases and reversed. Issue: whether the laws of Michigan, Kentucky, Ohio, and Tennessee, which define marriage as a union between one man and one woman, violate the 14th Amendment. Held: yes, the 14th Amendment requires a state to license a marriage between two people of the same sex and to recognize a marriage between two people of the same sex when their marriage was lawfully licensed and performed out of state. The fundamental liberties protected by the 14th Amendment's Due Process Clause extend to certain personal choices central to individual dignity and autonomy, including intimate choices defining personal identity and beliefs. Courts must exercise reasoned judgment in identifying interests of the person so fundamental that the state must accord them its respect. History and tradition guide and discipline the inquiry but do not set its outer boundaries. When new insight reveals discord between the Constitution's central protections and a received legal stricture, a claim to liberty must be addressed. Applying these tenets, the court has long held the right to marry is protected by the Constitution. For example, Loving vs. Virginia, 388 U.S. 1-12, invalidated bans on interracial unions, and Turner vs. Safley, 482 U.S. 78-95, held that prisoners could not be denied the right to marry. To be sure, these cases presumed a relationship involving opposite-sex partners, as did Baker vs. Nelson, 409 U.S. 810, a one-line summary decision issued in 1972, holding that the exclusion of same-sex couples from marriage did not present a substantial federal question. But other, more instructive precedents have expressed broader principles. In assessing whether the force and rationale of its cases apply to same-sex couples, the court must respect the basic reasons why the right to marry has been long protected. This analysis compels the conclusion that same-sex couples may exercise the right to marry. 4 principles and traditions demonstrate that the reasons marriage is fundamental under the Constitution apply with equal force to same-sex couples. The first premise of this court's relevant precedents is that the right to personal choice regarding marriage is inherent in the concept of individual autonomy. This abiding connection between marriage and liberty is why Loving invalidated interracial marriage bans under the Due Process Clause. A second principle in this court's jurisprudence is that the right to marry is fundamental because it supports a two-person union unlike any other in its importance to the committed individuals. The intimate association protected by this right was central to Griswold vs. Connecticut, which held the Constitution protects the right of married couples to use contraception, 381 U.S. at 485, and was acknowledged in Turner, Supra, at 95. Same-sex couples have the same right as opposite-sex couples to enjoy intimate association, a right extending beyond mere freedom from laws making same-sex intimacy a criminal offense. A third basis for protecting the right to marry is that it safeguards children and families and thus draws meaning from related rights of child-rearing, procreation, and education. Without the recognition, stability, and predictability marriage offers, children suffer the stigma of knowing their families or somehow lesser. They also suffer the significant material costs of being raised by unmarried parents, relegated to a more difficult and uncertain family life. The marriage laws at issue thus harm and humiliate the children of same-sex couples. This does not mean that the right to marry is less meaningful for those who do not or cannot have children. Precedent protects the right of a married couple not to procreate, so the right to marry cannot be conditioned on the capacity or commitment to procreate. The right of same-sex couples to marry is also derived from the 14th Amendment's guarantee of equal protection. The Due Process Clause and the Equal Protection Clause are connected in a profound way. Rights implicit in liberty and rights secured by equal protection may rest on different precepts and are not always coextensive, yet each may be instructive as to the meaning and reach of the other.